Hello, I'm Dr. John Picton, and in this equity short, we're talking about two equitable maxims that still matter. Those are, equity will not perfect an imperfect gift, and he who comes to equity must come with clean hands. A.W.B. Simpson, in The Rise and Fall of the Legal Treatise, tells us that maxims belong to another age. Before the development of textbooks and legal treatises, authors used to collect legal principles, that is, maxims, together. Often, they used to do it in Latin. Like textbooks, they were an attempt to systematise the law and bring order to it. It's a tradition that's gone. A.W.B. Simpson says, although maxims still feature in legal exposition, argument and justification, they are now regarded as slightly comical, and the form of literature directly related to them is dead. No one would write a book of maxims anymore. Whereas maxims used to exist in book form across the entire common law, they now exist only in equity, and even there, only as a bit of a curiosity. And so we can't disagree with Simpson. He's right. The maxims are disappearing, and they're often seen even as comical. But here, I want to try and do my best for them and identify two maxims that still matter. The first maxim that matters is equity will not perfect an imperfect gift. This maxim matters because it still has a life and impact on the law of trusts. The point behind the maxim can be illustrated by the case Milroy and Lord, where Lord Justice Turner used the maxim directly, saying there is no equity in this court to perfect an imperfect gift. In the case, a Mr. Medley, out of love and affection for his niece, Mrs. Milroy, attempted to transfer 50 shares by deed to a Samuel Lord. The shares were in the Bank of Louisiana. Under the scheme, Samuel Lord was to act as trustee of the shares in the Bank of Louisiana, and Mrs. Milroy, the niece, would be the beneficiary. Yet the trust, that is a gift on trust, to Mrs. Milroy as beneficiary with Samuel Lord as trustee, was not properly effected. In order to make a valid transfer, under the Constitution of the Bank of Louisiana, the transfer had to be made by entering Samuel Lord's name, and remember Samuel Lord was to act as the trustee, in books at the bank. That didn't happen. Presumably, Mr. Medley's name was left in the books of the bank. Mrs. Milroy, unsurprisingly, claimed that despite this failure to enter Samuel Lord's name in the books of the bank, was still beneficiary. She said she was still beneficiary. She was effectively asking the court to perfect the gift. She was asking the court to effect a gift that was imperfect because Samuel Lord's name had not been entered in the books of the bank. The court just shrugged its shoulders. Equity could not perfect an imperfect gift, and nothing could be done for her. Now, over the years, this maxim has been significantly qualified, as you can see from key cases which you study on all equity courses like Re Rose and Pennington and Wayne, but this maxim remains at least important as a starting point in judicial reasoning in gift cases. So it at least remains important in contemporary cases. The second maxim that matters is he who comes to equity must come with clean hands. The maxim matters because it has a certain intuitive appeal and because of its long history. Although, as we're going to see, sadly, the real-world application of the clean hands rule is quite far removed now from this punchy and pithy principle. In fact, there is no hard and fast rule that someone without clean hands cannot have recourse to equity. This is best explained through the case law. In Tinsley and Milligan, Milligan claimed that she was a beneficiary of a resulting trust in property that she had bought with her estranged partner, Tinsley. Milligan wanted a share in the value of the property that she had bought with her estranged partner. They'd bought it together with both their money. Both had contributed. The problem for Milligan is that the reason she didn't have ordinary legal title, the reason Tinsley was the owner, is that she'd been pretending to be a lodger so that she could commit a benefits fraud. Now, Milligan did not attempt to argue that she and Tinsley had a common intention involving a benefits fraud and that the common intention involving a benefits fraud gave rise to a trust sharing the property. Instead, she tried to avoid the benefits fraud entirely. Milligan said something much simpler, which allowed her to sweep the benefits fraud under the carpet. She said she was entitled to a share of the property, subject to a trust, for the simple and straightforward reason that she had contributed to the purchase price of the property. This is called a resulting trust. The resulting trust arose regardless of Milligan's unlawful behaviour. The resulting trust arose because Milligan had contributed to the purchase price. Put another way, Milligan said that she would have been entitled to a share of the property whether or not there had been a benefits fraud. Milligan did not have to adduce evidence about the fraud or rely on it as part of her case. The judges agreed they bought it. They agreed that because she was not relying on evidence of her fraud in making her case, she could have her remedy. And so at this point in the development of the law, the clean hands rule might have been stated as he who comes to equity must not rely on unlawful behaviour as the legal foundation of a claim for a remedy. This, for a long time, was called the reliance rule. He who comes to equity must not rely on unlawful behaviour as the legal foundation of a claim for a remedy. The reliance rule was not a million miles away from the clean hands rule, but now the law has shifted. And with that shift, our maxim has become a little less relevant. The Law Commission had recommended moving away from the old reliance principle in Tinsley and Milligan. And in Patel and Mirza, a case from 2016, the Supreme Court did just that. It shifted the law all by itself. The Supreme Court held, even where an illegal purpose is central to a claim, that is, the illegality makes up a foundation of the claim in court, the claimant might still be entitled to a remedy. Very broadly, the court held that from Patel and Mirza onwards, the question of whether someone has acted unlawfully and can be entitled to a remedy was a matter of judicial discretion. The judge will, however, consider some key factors which guide her discretion. If a claimant wants to rely on unlawful behaviour as the foundation of a claim for a remedy, the judge will now consider, and I paraphrase quite a lot, 1, why whatever legal rule the claimant has broken is important in the first place. I think this is just another way of saying that it's relevant to the deciding judge how morally bad the claimant's transgression has been. 2, whether or not denying the claim would run contrary to other legal policies. And 3, most importantly of all, whether or not there's a risk of overkill in denying a remedy to a claimant, whether or not it be unfair to deny a remedy to a claimant. This means that there is no longer any pithy and punchy rule. These guidelines will lead to different decisions in different cases, and so I think, perhaps a little sadly, we can restate the maxim in a more complicated way. We can say he who comes to equity without clean hands has no right to a remedy, but a judge has a guided discretion to award him one anyway. This is much less pithy than the clean hands rule traditionally stated, but you can see a connection between the maxim and the contemporary law, and for that reason it makes it onto our list of 2 maxims that matter. So we did find 2 maxims that matter, but still there's no doubt that A.W.B. Simpson is right. Maxims are becoming less relevant. They're disappearing from judicial discourse. In order for a legal system to have maxims, judges and academics must work together. The academics cook them up in books, and then the judges use them. And in modern times, neither judges nor academics have been interested in doing this. And so should we mourn the end of the maxims? Well, it's perhaps a shame that this type of legal writing is disappearing, as it's a shame when any type of scholarship disappears. But it should be remembered that judges apply principles all the time in their decision making. Every case decided by a judge always contains a principle. We call this the case ratio.